Hello friends, in the series on the income tax cases, today we will discuss the case of PP TELECELL Marketing Private Limited versus Deputy Commissioner of Income Tax. This case has been reported in 107 ITAT Tribunal at page number 401 and the matter has been decided by Delhi ITAT F bench and the date of the judgment is 11th September 2023. This case is regarding section 36 subsection 1 clause 5a, which talks about the disallowance for the amount which has been deposited late for the provident fund and ESI as far as the employee share is concerned. This matter has been finalized by the Supreme Court by the decision of the checkmate. So now there is not much dispute, but some cases arise where still there is a hope for the assessee. For example, in the present case, the assessee was disbursing the salary in the next month for which the salary relates. For example, if the salary is related to the month of April, the assessee was paying the salary in the month of May. So a very pertinent question arises that whether the due date of deposit of employee share of ESI and PF is to be reckoned from the month of May or April. When the assessing officer made the addition and the matter was before the ITAT, the assessee said that because I am paying my salary in the next month, so the due date of deposit will obviously come and should be counted from the month in which the salary is disbursed and not from the month to which the salary relates. When the matter was before the ITAT, the assessee also raised an additional ground by relying on the judgment of PR Packaging Service versus Assistant Commissioner of Income Tax that was reported in 101 ITR Tribunal Short Notes 8, and it was the plea of the assessee that the addition should not be made on the ground of the statement of the tax auditor in the tax audit report. But that case was applicable when the judgment of the Supreme Court in the checkmate has not come. So as far as the additional ground was concerned, the tribunal dismissed the additional ground of the assessee. Now as far as the main ground of the assessee, that whether the due date of ESI and PF should be reckoned from the month of the disbursement or from the month to which the salary relates, the ITAT remanded the matter back to the assessing officer and to decide the case by keeping in mind the decision of the ITAT in the case of Kanoi Paper and Industries Limited versus Assistant Commissioner of Income Tax. That case is reported in 75 TTJ 448 Calcutta, and ITAT said that if the assessing officer finds that the month of the disbursement is different from the date of the month to which the salary relates, then the assessing officer has to give the relief to the assessee. So in the nutshell, we can say that the tribunal has settled the issue on the point that if the assessee has disbursed the salary in next month, then in that case, the due date of depositing the ESI and PF should be counted from the month of the disbursement and not from the month to which the salary relates. It means the assessee is getting one more month for depositing the employee share of ESI and PF. So in this case, it can be said that the case goes into the favor of the assessee, and this case is like a boom for the assessee who has disbursed the salary in the next month to which the salary relates. At the end of this video, once again I am repeating the name of the case. The name of the case is PP TELECELL Marketing Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 107 ITR Tribunal at page number 401, and the matter has been decided by Delhi ITAT I bench. Thank you friends.